All right, so the purpose of today under amended instructions was very much that this would be about your questions to the two extraordinary women. I have a couple of questions looking backwards and looking forwards just to kick things off. And then we've got a roving microphone for the people in the room, and we're going to be taking your questions. I'm sure on a broad variety of questions. I reckon if we really wanted to be here, we could do a sit-in and stay for at least 48 hours to talk about everything that's happening with your thoughts and beyond. But Amanda, if we can just get you to start a little bit of background for us. RBG is an icon, of course, but when did you first become aware of RBG?
Reflect on this very happily. I would share this with students because I was so nervous about both the exams and the interview that it just kind of canceled each other out, which was good because I knew who RBG was. This was my dream job. And this is before she's famous. But because in the 1970s in our country, she was a leading advocate for gender equality. And through her advocacy alongside other brilliant women lawyers, she was able really, all of them together, to change the legal and social landscape of our country. And to finally, as a legal matter, have our Constitution recognize the equality of women. Those were the victories that she won at our Supreme Court. And the ripple effects of that have been tremendous. I was born in the 1970s, so I benefited from these victories, as well as the major legislative victories that she and her colleagues won in our Congress, including the passage of, for example, Title IX, which guaranteed equal opportunity to women in federally funded programs, for example, universities. So I knew all of this, and then now that I was in the third year of law school, I had read some of her opinions, including her crown jewel, as I call it, opinion in a case called Virginia Military Institute, which was a huge case in which she wrote for the court that VMI, storied state-sponsored military institute, had to accept women, even though it didn't want to. And that opinion is really a spectacular read. It's in the book. I asked the justice, if someone reads only a handful of your opinions, which ones would you want them to read? That was the first answer. The rest were dissents. I'll probably come back to that. So then I go and I interview with her, and I very rapidly get extremely nervous going in because, as I've said, I really want to know. This is somebody who is a hero to me by the time I interview with her. And how many people get to say they've worked for their heroes? It's not a common thing. So I was very hopeful, but also very nervous. And one of her many extraordinary qualities was that she did not walk on airs. As we say, she was not self-important. She immediately made you feel at ease and comfortable. And she went out of her way to do that with me. She realized how nervous I was. And by the end of the interview, it offered me the job, which was pretty fantastic, to put it mildly. I tried to contain my excitement and said yes as fast as possible before she could take it back. So then what happens in our tradition, you finish law school, typically before clerking on the Supreme Court, you will clerk for a year for another judge. So I clerked in New York on the Second Circuit, one of our lower federal appellate courts that sends cases to the Supreme Court, and came to her a year later. Each justice has 4 clerks. I think you call them associates here. And the work is really quite significant that you do at the Supreme Court. And this has been the fodder of much debate. Maybe it's too much responsibility. But what happens is the clerks divvy up the sum, usually about 8,000 petitions that come to the court in a given year. You clerk for 1 year. And the petitions are asking the court to take and review a case. And the court has almost complete discretion as to what it hears. So the clerks divvy up these thousands of petitions and write memos to the justices, making a recommendation as to whether a case should be heard or not. And that is a tremendous responsibility. The other major thing you do is once the cases are granted, you divvy up in each chambers the cases, and you work one-on-one with the justice. You write a memo making a recommendation as to what you think they should do. Of course, they're the justice, you're the clerk, you're often reminded of this. And then if they draw an opinion, you work with them in drafting the opinion. So one of the best parts of the job was working with Justice Ginsburg on opinions, because she was an exceptional writer. And to the extent that you are at all complimentary of my writing, it is because she edited everything I wrote.
in this book, and she remained a ferocious editor right up until the end. If I can indulge all of you, I'll tell a quick story about that. But what I did also want to know is that she had studied under Nash, who said that you can paint pictures with words. And that is really something that was very influential on her and why I think she was such a great writer. And she emphasized efficiency, never used 4 words when 3 will do. She emphasized clarity and accessibility, which I think is very important. We'll hear from a proper judge about that, but I think it was really important. And hopefully is reflected in the opinions of the book, that even if you're not a lawyer, you can pick it up, you can understand the dispute, you can understand the reasoning. But on that note of her being an editor, I sent her a copy of the introduction, which we had agreed I would write and would go under my name. But of course, we're co-authors on the book and she loves to edit. So she said, please send it to me. I'll just have a few notes, I'm sure. And I had clerked for her 20 years earlier and remember sending her draft opinions, and they would come back and the typescript, you couldn't even see it. There were so many markings on that page. She completely rewrote everything. And here I thought 20 years later, I've been a law professor for almost 20 years and, done a few good things in my own right. I'm a good writer. She's not going to mark it all up. So I send her the draft introduction and it comes back and you cannot see the typescript. And what's worse and most embarrassing is that she still worked on hard copy. So everything had been printed out for her, including my cover email. And she edited my cover email. So she was still teaching right up until the end, still editing, still trying to make me better. And I suspect I'm still a work in progress.
Well, I did want to come back to the idea of the long-term relationship we have and the continuing influence that she had on my life. But Helen, I did want to ask you, one of the things about being the first woman to achieve things is often you don't have another woman to look at further along in the field to say, this is the path that I can take. Can you reflect for a couple of minutes on what it was like in your career through law school and bar, that process? And I'll give you my mind as long as I get back.
Well, when I went to the bar, there were very, very few women at the bar. That's probably the most challenging part of my career was being at the Sydney bar in the 1980s. Yes, there were really almost no women who were well in front of me in terms of their seniority. There were a few, very few, and so it was just a sea of men. But although I and my peers didn't have really terribly many women to look up to, we did have each other and we formed very strong bonds. And I think that was what saw most of us through. There were quite a lot of dropouts. But I think I was something like the 35th woman to go to the bar in New South Wales. I mean, when I was at the bar, there were probably about 20 practicing women barristers out of maybe about 800. But we all hung together, and I think we gave each other a good strength. So beyond that, when I became a judge, which I was 42 when I became a district court judge, there were not very many women in senior roles within the judiciary, very few. But I had a lot of support from my male colleagues because unlike the bar at that time, it seemed that with those judges anyway on the district court, a judge was a judge and gender was far less important. So I had a lot of support from those people, many of whom remain friends today.
That actually picks up beautifully, and we didn't script it, but it's brilliant. Two things I wanted to talk to you both about, and that is the idea of the importance of relationships, mentoring relationships with your peers, and also the relationships that a senior woman in profession will build with those following behind and opening doors in that way. But also I want to flip to you both a broader question that one comes through the book and also through the documentary and the movie about Ruth Bader Ginsburg is the incredible support she did from her husband, Marty. And I don't, many of you in the room will know, or those listening on Zoom, Marty was a accomplished chef to the point that I believe the justices on the court after his death produced a cookbook of Marty's recipes. because they had been, or he had been beaten for so long in any events. And I just wanted to ask for the benefit of the young men who are listening online or in the room. Do they need to be intimidated? Do they need to be Martin Ginsberg style chefs in order to really assist women in the law? Or what can men do to continue to make things better?
So when I interviewed Justice Ginsburg in the interview about her life is the sort of the basis of the book, and the book is then built around it. I talked to her about this because my students always come to me and they ask me, how can we do this? How can we navigate having a family and working? And it's not just my female students, my male students ask me this as well. How can we achieve this work-life balance? So I put that to her and I said, what would you tell them? And she said, choose a partner who is as supportive of your work as they are of their own. And that was Marty. And I think that is a huge component, not the only, but a huge component to how someone of her generation was able to go so far in the profession. And it goes all the way back to the very beginning. He recognized that she was brilliant, she had great talent, and she had contributions to make. And he was very supportive of her becoming a lawyer. She went to law school with a toddler, which was totally unheard of. I mean, she's one of 10 women in her class, 500. Never mind also having a child. And then as her career took off, he was hugely supportive as well. He believed, and she emphasizes this in our conversation in the book, he believes that a father should be just as involved in bonding with the children as a mother. And so that was enormously important to him as much as to her. And what should not go overlooked is that Martin Ginsberg was probably the greatest tax lawyer of his generation. He was hugely accomplished and successful and revered in his own right in the profession, but they were just each other's biggest boosters. And when you had a front seat to their relationship, what you saw was two people who were both deeply in love. And when you reread her testimony when she was before the Senate at her confirmation proceedings, she made a point of thanking her in-laws because they had been so supportive at a time when women really weren't welcomed at the bar. They were few in number, as we've heard here as well, and that really made a difference. So I think it's having that supportive partner who's willing to share the load across the board and who really is as invested in your success as you're supposed to be in theirs.
Well, I would echo those thoughts, and I think the one thing that men can do is, and it's not a small thing, is to take their share of childcare responsibilities within the relationship, because that is the biggest thing that holds women back. And I think beyond that, by recognising in their own lives the importance of childcare, they can set a great example to their colleagues, their male colleagues within the workplace. That it is, they can normalise the idea that men are just as responsible for childcare as are women. Sometimes men regard men who take childcare seriously with some consternation, and that is an attitude that has to be changed, and can only be changed really by male example.
So, with so much happening in the United States, we could talk about the current state of the court for some time. And I imagine there's quite a lot of questions from the floor on that theme. But I'd like you to reflect for a minute, just before you go home. I know you're on holiday, although why people might choose to come to Canberra during their summer holiday is, again, you must be very pleased that Amanda is here with us. But before you get back to work, what do you see as the big looming challenges for gender in the US?
How long have we got? I think there are a lot. I think that right now we are in a period where many of us, including myself, think we're going back. And that is very distressing. It's very distressing because we were at a point at which we had accomplished, we believed, a very great deal. There remained a lot more left to be done. But now I feel like we're going to be fighting the same fights that we've been fighting for decades. And that's gonna take us away from moving forward to fight those remaining fights that were on all of our radars. And so the single biggest thing now, unsurprisingly, I would say, is reproductive justice and reproductive freedom. Because I agree with my late boss that women cannot be fully equal if they cannot control their choices and have that control over their reproductive choices. So that is really a major point in which we will be battling now for some time. And again, that's ground we thought we covered. I will say that another perennial problem that we continue to struggle with is having women rise, particularly in the legal profession, but in every walk of life, rise to positions of leadership. Because it's from there where you can really influence the values of a profession, a company, a firm, etc., and set examples about childcare and create a culture where it's okay to leave at 3 o'clock because you have to pick up your kids or take them to the doctor or whatever. And we're going to work around it. We're going to make this an environment where everybody can flourish, everybody can have a balanced life. And traditionally, that has not been the way it's been. That is what has held a lot of women back, because there's still a lot of the sort of traditional roles happening at home. And that's why, for example, childcare is such a big issue. And I think it takes women being in positions of leadership to recognize little things that make a difference. So recently I was put on a committee at my university, and they wanted to have a weekly meeting late in the afternoon on a weekday. And I wrote in and I said, no, I don't meet then. There are 6 other hours in the day and 5 days in the week. That's 30 hours. I mean, I can have this weekly meeting. Let's not do it at the end of the day, because I and others have obligations on the family front. And I can write my books at 3 o'clock in the morning. I don't have to be in my office and go to these meetings then. Let's try and pick schedules that accommodate people who are trying to balance all the many moving parts of their lives.
Now, the last question perhaps is tinged with concern, but I believe that this year we've had a sense of hope as well with the confirmation proceedings that you're particularly excited about. Would you like to reflect on that for a moment and then we'll throw it back?
Sure. So I had many lucky experiences in the year 1999 to 2000 when I clerked at the Supreme Court. I didn't just clerk for Ruth Bader Ginsburg. I worked down the hall from a woman named Ketanji Brown Jackson, who was clerking for Justice Stephen Breyer at the time and is our newest Supreme Court justice. And her appointment to the court is really quite historic. She's the first African-American woman to sit on our Supreme Court. And she brings, in addition to her identity, her background professionally, she was a public defender. And we've never had a public defender who made regular practice of criminal defense for Indigenous clients. We've never had someone from that background on our Supreme Court. And so I think she's going to bring enormously important perspectives to the court that have never been represented. And she's also happens to be brilliant and an absolutely extraordinary human being. I hope you'll find a way to bring her here to talk with all of you. And I think it's going to be a really exciting, great addition to our court in the short term. She's going to be writing a lot of dissents, but I hope that in time, we will see her speak for her court.
I know that there are a number of questions. I've spoken to a number of students already about having questions. I think there's a roving microphone here. So if I could get hands up, I know Satara and Grace have questions. So Satara.
Hi, thank you so much for your time today. I just had a question, given the current state of the court in the US and the kind of like hindsight. What is your opinion on whether RBG perhaps should have stepped down during the Obama administration?
Unsurprisingly, I get asked this quite often. Hindsight is 2020. You say, I don't know if you use that expression. I will tell you that at the time, she had been given a complete clean bill of health by her doctors. She had consulted with them about the state of her health and was told, you're cancer free, you're very healthy. So that factored into the decision. The other thing that factored into the decision, I think, for her, and I'm speculating, but I'm fairly confident in this, is that she loved the job and she loved public service. And you have to know a little bit about her family and her background to understand how passionately that was true for her. Her family, her parents and grandparents fled the persecution of Jews in Europe in the 1930s. And the United States welcomed them in and gave them opportunities. And as she liked to say, she went from one generation of a bookkeeper in the garment district to being a Supreme Court justice. And that's something that was really special about her life and reflects some of the best aspects of our country. And I think she felt very passionate and patriotic about her love of country. She felt very grateful and really truly loved being a public servant. So for her, that drove this deep commitment to serve. And I think it's reflected in her entire career. Final thing I will say is I imagine she would have stepped down had Hillary Clinton been elected president. I think she would have taken great pride in stepping down and having the first woman president of the United States and her successor. But things didn't work out. And when I think about whether a lot of people are very critical of her decision, look, I'm the clerk, I wrote a book with her, I love her dearly, I'm biased perhaps, but I think the blame belongs elsewhere. Justice Scalia died, President Obama had nominated Merrick Garland, now our Attorney General, to the spot. The Senate under Mr. McConnell's leadership would not hold a hearing. So we all knew as we went to the polls that at least one spot on our Supreme Court was in the offing. And when they did exit polls, the number one reason Republicans said they voted for Donald Trump, or anyone, whatever party said they voted for Donald Trump, was the Supreme Court. When they asked people, why did you vote for Hillary Clinton? The Supreme Court was the 5th, 6th, 7th, 8th answer. So they just weren't focused on this. And I find that quite surprising, given that there wasn't an opening at the time. And we had several justices in their 80s, multiple justices in their 80s. But it is what it is. And as a result of that 2016 election, Trump gets 3 appointments. And that is why we are where we are. And even if she had stepped down, we would be here. It would be a close report, but we would still have dogs. So I do think she gets unfairly blamed. But it is what it is, and we are.
Did you want to reflect on the judicial appointments and retirement for the woman in response to that?
You had to retire young, sprightly, and off now to do other things.
Oh, but I didn't have to retire. That's true. I wasn't quite of the age where I had to retire. Yes, actually, I was interested. It occurred to me that I should ask a question about myself, which is, in your view, do you think there should be a compulsory retirement age? Because the idea that several of the judges on your highest court are in their 80s, I find frankly a little frightening. I mean, how can you imagine that somebody in their 80s is at their sharpest side? What's your view about that? And no reflection on RBG. She could be the exception to the rule. What about the rule?
So it's interesting because when you go to different jurisdictions, even within the United States, but also overseas, like here, you have some jurisdictions where there are mandatory retirement ages. And sometimes you meet judges who are pushed out by that, and they're very resentful because they feel like they have a lot left to give. And of course, we're all living longer, so the benchmarks tend to change. But sometimes you hear, well, this is good, and it can be good for a lot of reasons. You get turnover, which isn't a bad thing. You don't have whether it's the exception of the norm of the hangers on. We have plenty of stories of that on the U.S. Supreme Court. We have justices renowned for at the end of their time, they're not doing anything. The law clerks are literally doing everything. RBG, I think, was the exception because I think if you read some of her opinions, even in the final term, her very last opinion was a dissent in a reproductive rights case, and it's fantastic. I tried desperately to get her to include it in the book, and she said, "No, your opinions. I pick the ones. These are my babies." But I do think that we're getting more and more political in our appointments, and we need to rethink perhaps wholesale what we're doing. And I've become convinced, I think the better approach for us would be to have 18-year staggered terms. Each president in 4-year administration gets to appoint 2 justices. That way we have consistent turnover, but a long term. So you can really settle into the job, you can really do your thing, but then you cycle out. You're gonna have some of the same concerns. You might have people get appointed really young and they get out, they're looking for jobs, and maybe there's a potential conflict at the end. But on balance, I think it's a better system. And I also think one of the pros of it is that it very concretely ties the appointments to the election. So we're not hiding the ball from some voters who don't appreciate that connection. Hopefully that would be clear. But to do that, we have to amend our constitution because judges, federal judges have life tenure in our constitution. And we don't amend our constitution very often, and it's extremely difficult to do. And although many people are talking about making changes to our court, there's really no movement whatsoever to amend the Constitution. And I do wonder though, I've said this a couple times recently, if the gun issue might finally prompt a serious conversation about constitutional amendments, and then maybe this becomes part of it. But I don't see any of that happening right now. I think I'm literally the only person saying this, along with the late Justice John Paul Stevens had suggested this a few years ago in his final book. It really didn't go anywhere.
For those of you who are interested in judicial appointments in Australia, do have a look at the like Australian Law Reform Commission report. The chapter on judicial appointments is beautifully written and very insightful, and it should be a starting place. And Grace, you had your hand up before on very questions. Couple of numbers down the front.
Thank you. Thank you for talking. I have 2 questions actually, if that's okay, and I'll make sure to ask one, and then if I have another question to ask before I ask the second one. My first question was just a reminder, actually, in your comment just then about how the judicial appointments are becoming more and more political. And I wanted to ask your opinion on what you thought about that process of the sort of increasing politicization of the judicial appointment. Because I guess reflecting back on Australian circumstances, we of course studying government that will be making in the next couple of years some very significant and important, at least I consider, judicial appointments, particularly in the High Court. And I wanted to ask what your thoughts were on that politicization of the judicial appointments, and whether you think there should be less of that, or we should continue in that sort of tradition.
What is happening in the United States in the last decade plus, with respect to particularly the appointment of federal judges, is that we have 2 camps of judges that are very different. And I think when I was in law school and reading opinions and clerking, I didn't see that as much. We saw judges that sort of spanned a spectrum, and there were a lot here in the middle, and there's less of that. There's less of that, particularly, and I'm going to play my cards, particularly on the right. They're very much on the right. There are fewer and fewer moderates that are being named to the courts by either party, but especially on the right, because of their screening processes are designed to identify people who want to overturn Roe versus Wade, perhaps want to overturn a verdict on the decision that recognizes the right to same-sex marriage, etc. Have a particular approach to interpretation. And I think it's unfortunate, because one of the things that I hear from the judges I know is that there isn't as much of this engagement. And we have a judge here, so she would be better to answer this part of it. But I tend to think that there's real value in having judges on multi-judge panels being in conversation with each other, really listening, really trying to understand the other side, and sometimes meeting in the middle. And we're seeing less and less of that on the federal courts, increasingly and rapidly so. And that is not good. That is not good for the development of the law.
Well, I think that very fortunately here we have very little politicization. I mean, there may be political appointments, but that doesn't mean that they're going to toe the line once they get on the bench. So just coming to the question of the multi-judge panels, my experience here in the ACT has been that we've always aimed to get unanimity, even if we don't all agree 100% with everything that's in the judgment. If we can get the key points, we can all compromise a little bit and we can speak with one voice. That is really helpful for practitioners. And it also results in a better judgment overall, because I've sat on in a number of different environments on multi-member benches in administrative tribunals in various environments. And there's no doubt that when people put their heads together in a genuine way, you get a better result.
And I think picking up on some of those themes, you would both be in agreement that the best possible way to have a multi-person panel gnashing out these ideas is that diversity in opinion, political strife, if you like, and values, but in gender representation, but also ethnic and cultural diversity too, and bringing the best minds from all societies to the question. You were talking, Amanda, before the session today about the Ginsberg Scalia initiative. Could you give us a bit of background on that? Because that fits very nicely into the broader themes of how do we reach that decision.
So some groups in the United States, including prominent government groups like the state attorneys general for all the states, have started various initiatives named for Ruth Bader Ginsburg and Antonin Scalia. And the idea is to get those communications happening across party lines in a civilized, respectful manner that appreciates we all love our country. We're all trying to do good. And we need to come together and we need to understand the other side and engage and work together. And I think these are really healthy and important initiatives that are happening in our country, because that's not what's happening in our politics at all anymore. I was invited to talk to the state attorneys general about this, and I thought long and hard about it because I value their friendship. They were great friends. They both stressed when interviewed about this, even though they had divergent views about how to interpret the Constitution and a lot of key hot button issues, they always stressed what they had in common. They stressed they came from immigrant families, that they love their families, that they love the opera, they love wine, they love the law, and they love this country. And those were sort of the founding principles that brought them together. They both were deep intellectuals, former professors. And she gave a speech at his memorial in which she emphasized that his dissent in that BMI case that I referenced, he was the only dissenter. She said it made her opinion better because it forced her to really think through her arguments and make them stronger. And the resulting final opinion was so much better. She claims that. I'm pretty sure the first draft's in it too. But it was when I was giving these remarks, there were a few people in the room who had been cheering on what happened at our Capitol on January 6th. And so I thought very hard about how I would describe their friendship. And I chose my words very carefully, and I emphasized that it was critical to that friendship that they agreed on certain first principles, that we resolve disputes in our country under the rubric of the rule of law. That we respect the separation of powers, that we respect the democratic transitions that happen during free and fair elections, and that if we don't have that, we can't have that. It's not going to work. And so that is really the struggle that's happening in our country right now, is that there's some people who don't even agree on the grounds. And it's very hard to engage with someone when that's the case. And that's an important distinction.
So your question.
Thank you both so much for your insights. I have a question for Justice Murrell about, it's actually just bouncing up Helen's question earlier about what are the biggest challenges in the US. I'm curious what you think the biggest challenges are in Australia, and particularly in the legal profession for gender equality. So you've both spoken really insightfully about family and relationships and how important our personal lives are, but that's still kind of taken on the shoulders of the individual to figure out their personal lives so that their careers can work. So I'm really curious what your perspective is in the legal profession in Australia.
Well, so the biggest challenges for the profession.
Look, to be honest, I don't know that I'm qualified to answer that, having been in a very small part of the profession, the judiciary for so long. I'd say, that probably the challenges are the same challenges, for most of the professions and indeed for the workplace generally. I think that the old model of the large firms and working the young people, 24/7, and the focus on billing, surely there's got to be some rethinking of that, because it's ultimately achieving nothing. It's driving people away from big firms. It's driving people away from the law, losing a lot of good people, and also causing a lot of harm to a lot of people. So what's the point? There's going to be reading. I think a lot of big corporations in the business area, I think they are having a big reading, and COVID's also making that big reading. I don't know whether it's happening with big firms as much. I simply don't know. I'd like to think it was. I suspect that maybe it's not. I just don't know. Yes, I mean, there are lots of obviously other challenges, one of which is achieving greater diversity across every aspect of the legal profession. And now I think that the biggest diversity issues actually don't relate to gender. I think there's been a lot of headway made there. The problem's been identified, and is well on the way to being addressed. Not to say that there aren't battles to be fought, but I think there's bigger diversity issues. People with different ethnic backgrounds, different religious backgrounds. I think that they will be the biggest diversity challenges going forward.
We need to reflect on the fact that the first Indigenous state court officer, judicial officer, was only appointed a couple of months ago. So Kim, you have a question?
Thanks very much, Amanda. Kim Rubenstein. Your point about her respect for the separation of powers makes me ask if the decision in Attorney General and Santos Morale was included. And just for the background for those here, it was a really interesting case. I was part of an amicus for statelessness professors for it on citizenship by descent, where there was discrimination between children born abroad of fathers, US citizen fathers to US citizen mothers, and those fathers were disadvantaged. And she authored a unanimous opinion that took months and months and months to come down, which found that it was discriminatory. But the way it appeared she resolved it was to agree that because it was discriminatory, it needed to go back to Congress. And so the applicant who was disadvantaged didn't win in practice, because ultimately they said all children, whether from fathers or mothers, would have the worst scenario, so that they had to live there for 10 years. So the decision was strong on anti-discrimination, but not on the actual impact of the individual. And others have commented the only way she could get the unanimous judgment was if that was the result. And I'm wondering if in that balancing act, in unanimity, there is sometimes a loss involved that is actually significant for justice, just as thou shalt pursue.
Right.
So it can be, and I do not know the background of what happened behind the scenes, but I've always assumed that that was part of maybe even getting to 5. So with 9 justices, you need 5 to win, and maybe that's what it took, because I again, I don't know the background, but I doubt she would have fixated on unanimity, but I think she certainly would fixate on counting 5 and getting the win. So I don't know, but I also know that she, if you go beyond that case and look at some of her other cases, she very much tried to stay in her lane as she saw it, and not to overstep, and really not to be subject to criticism for legislating from the bench. And sometimes that meant for litigants, maybe they didn't get everything they wanted. But for her, I think she thought there was a larger principle at stake, and it cut in different directions, because there are jurisdictional cases where she wrote for the court, I think, really important decisions about we need to understand there are aspects of our jurisdiction that Congress does totally control. So to give a concrete example, if it's a constitutional issue, Congress can't tell us how to decide a constitutional issue because we're the ultimate deciders of that in our tradition, she would say. But there were important decisions where she wrote the report where Congress changed the underlying law, say, for example, of foreign sovereign immunity. And that law is totally under the control of Congress. And you have the court dividing over whether Congress can do that and have the jurisdictional implications for it. And she wrote, I think, correctly for the court in case of Markazi and in some other decisions that yes, when Congress controls the law, who are we to tell them what the law should be and then the jurisdictional implications follow from that. So I think of that when I hear that question. I think of someone who was really trying carefully to navigate, making sure that when she flexed the judicial muscle, she was fully in her lane, but always respectful that she was part of this larger structural backdrop and that she had to respect that there were limitations.
Hi, thank you for inspiring lesson. And here is a question I'm really curious about. So there is well, I think that about RPG, an important factor causing her great social icon was that she was always not angry, and she had gone for marriage, which follows the mainstream value of the society. And does it show a social phenomenon or a trend that if you want to make a difference, it's important to follow the mainstream value of society, which excludes those who don't follow? And yeah, I'm really curious about what you think. Thank you.
That's a great question. I would separate out that she was in a heterosexual marriage and that she was very calculating in how she went about accomplishing what she accomplished. I would like to think that we can separate those out at this day and age. I could be wrong, but I think the more important lesson to take from her success as it translates to today and an environment where hopefully we're moving in a direction where to borrow from her, each person can achieve their full human potential and contribute based on their individual talents and capacities rather than on stereotypical expectations. I think what was really important to her success was that she did try to bring people along. And that meant that sometimes half measures, and it might even apply to the decision we were just discussing, but you get people fully on board as you move forward toward greater equality of opportunity and more non-discrimination. Instead of angrily winning one-off victories, you bring more people along, the change will be more lasting, it'll be broader, it'll transcend individual cases. And I think that's how she thought about her advocacy in the 70s. And it explains a lot of how she judged. And one of the ways that she did that, for example, in the 70s, is she often chose clients who were men. And she did that because, we've heard a description of you coming to the bar, when she came to the bench, when she came to the bench, there were, by the time she came in 1980, there were literally, you could count on one hand in 1976 how many federal judges there were out of hundreds were women in our country. So the Supreme Court is 9 men. She's got to convince this judiciary that discrimination runs in multiple directions and affects people and holds people back no matter what their gender. And so she was very thoughtful about that. And she knew, to go back to something that the Chief Justice was saying, she needed men to be the allies in this fight. And so that's part of how she thought about strategizing her advocacy. And I think that's the more important component that translates to today, because if you don't bring people along with you, any victory is going to be short-sighted.
Well, thank you. I think the question might have been about
whether you're more likely to succeed in a conventional society if you look conventional and act conventional. Well, superficially, I think yes. This would decide whether RBG did fit that mold. I would question that, but I also think that why bother? Why bother being anything other than what you are? I think that what's more important than looking conventional is being confident in who you are in your own skin. And I think people accept that. Particularly, I would like to think in the law, where for people who are really involved in the law, it's about the law. So if you're a good lawyer, if you're a person of integrity, that should be enough. And so I don't think these days I would hope that you don't have to present yourself deliberately in a conventional way in order to succeed.
I think it's time now for Penny. I don't know if you have a question, Penny, as well as
Do we-
Joe Bank, but I think we have
Do we have time for a question?
a very brief.
One more? Okay. It's relatively direct and it's about Roe versus Wade. I mean, how can we not when there's an American among us? I want to know if you saw it coming, and I want to know if there are going to be decisions, imminent decisions of a significant nature, whether you will have seen them coming as well, with the makeup of the court, with the political appetite. Did you see it coming? And Helen, I'm wondering if you think anything of that gravity could happen here. I think abortion's relatively safe in Australia, but something of a similar magnitude, do you see something in the pipeline that could shake the foundation of the Australian legal system like Roe v. Wade has in America?
Now, I don't think it'd be very short. answer.
Sorry.
Yeah, it's been a brilliant question. Maybe we can continue after the Zoom stops, but brief.
I saw dogs coming and not because the opinion was leaked. To know the kind of justices that were being put on the Supreme Court, it meant nothing to me that in their confirmation proceedings, they said, "Roe versus Wade is sound law." These are individuals whose life work was to enroll with Roe versus Wade, so it was no surprise to me. The question is, how far does this go? What's next? And there is a vibrant debate among legal scholars like myself who do constitutional law and follow the court as to what is next. Some are optimistic that maybe there won't be more. Unfortunately, I'm not in that camp. I think the reasoning of the dog's opinion suggests that a lot of other, what I would consider to be foundational, ancient as well as recent privacy decisions are in jeopardy. So we'll see. It's an interesting time. And unfortunately, I'm not using the term interesting in a good way. But we'll see.
How's that for brief?
Yeah.
Perfect, and also I think we're trying very hard to get a man to come out again next year. So we
Okay.
can have an update.
Round
on
two.
that. Helen?
The very short answer is no. I don't think anything like that would happen here. But I guess the qualification is that the common law is based on precedent, so it's based a little bit backwards. So there's a natural pull towards conservatism, which may also be something that's safe, which may make people think.
Yeah.
Oh. You guys are wonderful at the brief.
A Penny, back over to you.
Absolutely. I will stand up so I can be as sincere as possible. So my name is Penny. I'm here on behalf of the Women Law Association of ANU. And I would like to sincerely thank our speakers for coming out today. I'm confident that I speak for everyone in the room when I say it was a pleasure to bear witness to these discussions today. So Amanda and Helen, thank you for coming to our campus in Canberra and for talking us through your very deep and diverse experiences in the law. Thank you also to Helen Murrell and the College of Arts and Social Sciences, the entire CAS marketing team. Events like today just don't happen without you guys, so a sincere thank you. Thank you also to the Global Institute of Women's Leadership for coordinating the event and ensuring everything went smoothly today. A very big thank you to Heather Roberts, a personal mentor of mine and a wonderful chair who facilitated a really brilliant and balanced discussion. And thank you for everyone for coming out today, for taking the time. Happy Monday, enjoy the rest of your day and the rest of your week.